All right, hello and welcome once again. Welcome back to Employment Law Show here. John Scholes beside me, Lior Samfiru, co-founding partner, Samfiru Tumarkin LLP, the most positively reviewed employment law firm in this country. You can check that out anytime. You can actually call and find out as well. Lior's team anytime you would like, 1-855-821-5900. The email address we use all the time on or off air is help@employmentlawyer.ca, and a website built just for you. Anytime you can use it, free and anonymous, and rolled into that is a severance pay calculator, which will be referred to several times during the next 30 minutes. That is pocketemploymentlawyer.ca. Lior, on the show today, we're going to talk about parental/maternity leave, a very hot and important topic. That's coming up in just a bit. But we always start, pal, with the week that was. How are you?
Hey, John, I am great, and I'm ready and excited to talk about employment law and hopefully inform and educate you about your workplace rights. Let's be clear and let's be honest. Workplace rights are important. We all have jobs. We all spend so many hours at work. Well, many of us don't know what our rights are, and it's easy to think that the law is not good. A lot of people think, well, we don't have good employment laws. Well, that's wrong. The reason why you think that is because you actually don't know what the law is and what your rights are. We have excellent employment laws in Canada. And what we do on this show every week is tell you what those are, help you understand what those rights and enforce those rights, and give you some answers to the questions that I'm sure you're struggling with. Over the last 2 years, employees have had more questions than ever about workplace rights, whether it's temporary layoff or vaccine mandates or changes to your jobs or being let go. So if you have any issue or question, it doesn't have to be related to the pandemic. Over the next 30 minutes, a lot of those questions are going to be answered. But of course, we only have 30 minutes, and if we can't get to your question specifically, not a problem. You have the option to contact me in the office so we can have a private chat about your matter and get your answers to you that way. We'll give you that contact information throughout the show today. But now that we know what we're here to do, let's go ahead and do it. Let me start talking to you about a situation that came across my desk over the past week. So it's often the situation when you're let go, you get a letter of termination. So you know you've been let go. It's in writing. Your employer says so. Today's your last day. Tomorrow's your last day. Well, sometimes that actually doesn't happen, and employers think that they can avoid telling people that they're terminated, but act as if they are. Let me give you a prime example of that. I spoke with a gentleman who had worked in a restaurant for a number of years, and every week he'd get his schedule, his shifts for the following week. There's usually not too many changes, work fairly consistent hours. Well, one week he noticed he wasn't on the schedule for the following week. He asked his employer about it, didn't really get an answer, he said, we'll see, we'll get back to you. Same thing happened the following week, and before too long, his employer stopped even getting back to him. Now, he was never told he was let go. He wasn't given a letter. He wasn't given a record of employment. He just wasn't scheduled anymore. And he contacted me, of course, and he wanted to know what his rights were. So here's the thing, John. Of course, this is a termination. The most basic aspect of the employment relationship is that you make yourself available to work and your employer schedules you for work, gives you work. That's what employment is. Well, in this situation, his employer stopped giving him work. That's a termination. He's been let go. Doesn't matter what the company wanted. Doesn't matter how they refer to it. He was terminated. It would, in fact, be impossible for him to be more terminated than he was. So, of course, he's owed severance. For him, that's as much as 6 months' pay. He had been there for just under 4 years. I'm going to help him get that severance. But I wanted to remind everyone there, especially employees, that if you don't get work from your employer, that's a termination. Whether your employer says something else, maybe they refer to it as a scheduling thing, as a layoff, a temporary layoff, it does not matter. If you don't have work, you've been terminated, that triggers your severance entitlements.
Would there, he reached out obviously because he realized who you were and you're going to help him, but would there have been a time limit if he just let this fester for much longer? Would he have been under that two-year time limit?
Absolutely. So if he stops being scheduled, that triggers the limitation period. So he has 2 years from that point, from when he stopped being scheduled, to pursue any matter. There's a 2-year limitation period, John, and every week I get contacted by someone that hears one of our shows or reads something that I wrote and contacts me. But unfortunately, their issue arose more than 2 years ago. So certainly, it's not a good idea to sit on your rights. If you have an issue or a question, even if you're not sure if it's a real issue, better to pick up the phone and call so that you don't lose out on your limitation period.
Could you get the temperature of what this employer was thinking by doing this? They just figured out, we'll just forget about this guy, he'll go away, or maybe maybe they didn't realize they would have to pay him any severance. They didn't realize they'd actually let him go.
I think they knew exactly what they were doing. They were just hoping that this guy's going to go away, find another job, and kind of forget about it, kind of, see the writing on the wall. And he did, and he is. But he still owed severance. You can't end someone's employment and hope they go away and avoid severance. At least you can't do that legally. Now, some people may not have realized that they have rights and options. Luckily, he called me, and that's why, again, 6 months severance, that's a lot of money. I don't care who you are and what you earn. 6 months pay is going to be a lot of money.
Employmentlawyer.ca, by the way, the firm website. Go there for all things, of course, having to do with employment law. You can also find where the TV and radio show is scheduled, and there's a list there as we do the radio show across the country pretty much. Tune into that. It's an hour-long broadcast every week, several times a week, as a matter of fact. On those radio shows, Lior, as you know, we get a ton of great phone calls. People want to know stuff. They're learning constantly, which is good. And we take some of the, we cherry-pick a few of the phone calls. We play them back here on the show here on TV. So we'll get to our first call for today, Lior, right now.
Just lost a big contract at work, so we're looking at a bunch of layoffs. I was looking at the employment standards minimum. Just wonder if you could clarify something for me. It says I'm entitled to 1 week, or every a year I was there for a minimum of 8 weeks. What does that mean?
So how long have you worked for this company?
15 years.
And what kind of a job and how old are you, Matt?
42, and I am a machine technician.
Well, John, this goes back to the single biggest misconception in employment law. And that is that when you're let go, your severance is a week's pay per year of service. And why do people believe that? Is because they can go online and they can access the employment standards legislation in whatever province you're in. And that's what you're going to see, a week per year, 8 weeks max maybe. And well, it says that, it's legislation. I know how to read. So clearly that's what I'm owed. Wrong, wrong, wrong. That legislation, employment standards, only outlines a person's minimum entitlements. Those minimum entitlements are irrelevant, frankly, because virtually every employee has greater entitlements, more entitlements, based on common law, what our courts have decided over the past 150 years. So yeah, your minimum entitlements may be a week's pay per year of service. Your full entitlements can be 10 times that, 50 times that, depending on a number of factors. So rather than me just kind of tell you, let me show you an example. So we had this call that we just played from our radio show. So this person's been there for 15 years, and he believes, based on the Employment Standards Act, that he's only owed 8 weeks severance. Well, let's go to pocketemploymentlawyer.ca, and let's use our severance calculator feature, which, by the way, allows you to find out your full entitlements. And let's see how much this person is actually owed. So he's 42 years old, been there for 15 years. Severance, he believes he gets nothing or very little. Well, you see at the bottom of the screen, he is owed as much as 16 months' pay. 16 months' pay. Now, if his salary is $74,000, that's about $96,000 that he is owed. So that's how it works. And the same for you at home. Doesn't matter if you work for 2 months or 20 years. If you lost your job, you're owed much more than a week per year of service. Go to pocketemploymentlawyer.ca, use the severance calculator, find out for yourself.
Yeah, it's really simple, it's really free, and it's quick to use. Again, severance pay calculator, as Lior just said, pocketemploymentlawyer.ca. Check it out. Even if you haven't used your job, just take it for a spin, as we say, and see what you would be owed if it ever came down to the time where you were let go and wondering what you're owed. Terminationquestions.com, another great website we offer. Lior, free. You can ask your questions there. It's anonymous, and they get answered by someone on your team as well. First one for today comes from Sloan. Sloan says, my supervisor harasses me constantly, saying that I am unproductive and unqualified for the job and insists that I retire. There are many days when I feel scared to go to work. I filed an internal complaint, but nothing has been done. Should I just quit? No.
Well, the answer to the question, of course, is an obvious one, or hopefully is an obvious one. Absolutely, you should not quit because you've done nothing wrong. Sloan did nothing wrong. It's her employer that's doing something wrong. Now, let's be clear here. An employer has to take harassment and bullying allegations seriously. It's the law. It's not just the right thing to do. It's the legally required thing to do. So Sloan did the right thing here. She filed a complaint. Nothing really has happened. Well, she needs to follow up in writing so that there's a record. If nothing is done, then that could potentially be a constructive dismissal. It could also be a human rights violation. It looks like Sloan is maybe picked on because of Sloan's age. Her employer is saying Sloan's too old, perhaps. Well, in that case, again, it's a human rights violation as well. So if you are subject to harassment, tell your employer in writing. File a complaint if you need to with HR. Follow up if you need to, again, in writing. If your employer drops the ball and doesn't do what they're supposed to, which is to investigate and fix the problem, you reach out to me and we can deal with it externally. But do not quit, certainly not before you speak to me.
You know, this one was pretty obvious with this employer insisting that Sloan retire. I mean, that's beyond the pale. But could it be a human rights violation in the same way if it's a little more subtle, like, you know, this person maybe in Sloan's case, you know, starts receiving, you know, timeshare in Florida pamphlets on her desk from the boss and little hints and, you know, dropping little suggestions that maybe it's time to wrap it up? I mean, that could be just as much of a harassment, right?
Well, it's not just a coincidence that you bring this up, because you recall you and I spoke a couple of years ago about this client that I had where that's what his employer did. Left all kinds of retirement package or pamphlets on about retirement resorts. It's the same thing, right? It's inappropriate. If your boss is telling you, suggesting to you that you should retire, that you're too old to work there, that's a human rights violation, okay? You cannot be discriminated against or pushed because of your age. We have no longer in Canada retirement. You can work until whatever age you want to, and if your employer won't let you, yeah, you better believe that's a problem.
Let's take a short break. Maternity/parental leave, some points on that coming up. Stick around for it. It's important stuff. In the meantime, 1-855-821-5900 and help@employmentlawyer.ca is how you reach out to Lior. Lots more coming up. Employment Law Show. Stick around. People think you should go to the government to get severance pay. Employmentlawyer.ca says that is a myth. Government can only help you get minimum severance, but not everything you're entitled to. Always check with the employment lawyer first at employmentlawyer.ca. If your long-term disability claim is denied, should you appeal?
Appeals often fail because insurance companies control the process. So long as you appeal, you're playing by their rules.
You should never appeal the denial of your disability benefits. Appeals are just a mirage of false hope.
Don't. That's their process. Take it out of their hands and fight for your rights with our help.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think their employer can make changes to their job. Employmentlawyer.ca says that is a myth. Your employer can't change your pay, hours, or duties. You may be entitled to full severance pay. Always check with the employment lawyer first at employmentlawyer.ca. Okay, welcome back. Employment Law Show. Good to have you along. John Scholes here, weekly with Lior Samfiru. Reminder, co-founding partner, Samfiru, Tumarkin, LLP, the most positively reviewed employment law firm in the land. Do not ever hesitate just to reach out if have just a conversation with Lior, a member of his team. If you've got some issues at work, or maybe you don't, but you think it might be in the future, just call 1-855-821-5900, help@employmentlawyer.ca. And one of the reasons you may be calling, if not now, maybe in the future, that would be a parental or maternal leave, maternity leave. And there's all kinds of questions regarding this. Lior, I want to get into some of these, ask you a bunch of questions about it, because it's a real gray area with people, both employees and employers as well. So the first question I have for you, who qualifies for parental leave?
Well, John, it's disappointing that in this day and age, we still have to talk about these things and remind people of the law, because the law is actually not complicated. The problem is that employers often get it wrong, or the employers often, frankly, don't do what they're supposed to legally. So it's important to remind everyone, employees and employers, about the rights that employees have when it comes to parental leave, maternity leaves, and remind them also that these laws are entrenched. There's really very little exceptions to them. So as I said, the first question, of course, is, well, who qualifies? Now, every province is a bit different, but generally, those that qualify are new parents. whether it's a mother or a father or those that are adopting a child, qualify for what we call protected leave of absence, time off that's protected where the job is protected. Now, depending on your province, you may have had to work a certain period of time before you've had the child, before the due date or before the child comes into your care. Usually it's 3 months. You would have had to work for the employer for 3 months. In those situations, if you've worked long enough before the due date and you're a new parent, then you qualify for this leave of absence. You qualify for time off where your job is protected, one of the most important aspects of employment law.
You know, you and I both have friends and family member stateside, and it's remarkable how short the maternity/paternal leave down there is generally. It's a matter of weeks in a lot of cases. Up here, generally, you said it changes from province to province, but generally, how long is someone allowed to go off on a family of your maternal leave?
You know, I started off the show by saying how in Canada we have good employment laws. Well, this is an example of it, because our neighbors down south have much worse laws. They don't have time off or anything significant if you've had a baby. You're back to work in a few weeks. Whereas in Canada, in most places, you can be off, John, as much as 18 months, 78 weeks for if you've had a child. Now, that's a combination of maternity leave and parental leave. For fathers, that may be a bit less. For fathers, that could be as little as 61 weeks. But generally, for a mother who's had a baby, who is pregnant and had a baby, she can be off for as much as 18 months total. That's a long period of time, and that's time where your job is protected. And that's a time where you're supposed to dedicate, of course, to being with your child, to getting healthy, and to bring them to a state where you're comfortable going back to work and leaving them with hopefully another care provider.
Because it's such a robust time, can a parent, mom and dad, or mom and mom, dad and dad, can they break it up? Can they take half and half? Is that possible legally?
Yes. So parents are allowed to split that, and so that a period of time is taken by the father and a period of time is taken by the mother. A lot of parents choose to do that, and you qualify for EI benefits during that period of time.
Right.
So whereas an employer doesn't actually have to pay an employee while they're on maternity leave or parental leave, you get EI benefits for 18 months. Now, some employers do have policies that they top up EI and they pay a portion of someone's salary, but legally there's no requirement to pay an employee, but that's what EI is for.
Kind of an obvious question here, but I'm going to throw it out there anyway. Can you be fired for taking a parental leave?
Well, you know, it is an obvious question, and which has an obvious answer, but employers get this wrong. So Let's be very clear. This is what we call a job-protected leave of absence. So if you're pregnant and you're taking pregnancy leave, parental leave, if you're a father having a new child, you have a job-protected leave, meaning you cannot be let go because you're taking the leave. Your employer may not be happy. They say, well, my gosh, 18 months is a long time. I'm not happy. Well, you know, too bad, frankly. You cannot be let go. You cannot be penalized. Your job cannot change. Your hours cannot be reduced. You can't all of a sudden get these mysterious disciplinary letters. Nothing can happen to you because you're taking parental leave. You have a right to your job. Your job is protected, and you have the right to take that time without consequences.
So at the end of up to, potentially 18 months, if the parent chooses to use the whole thing wherever they're situated, what are their obligations? What are their rights when they come back from this parental leave?
And this is where I think employers get into the most trouble, and that is an employer has to take the employee back to the same job at the same pay, at the same location that they had pre-leave. Now, if the pay has increased for that job, then they have to get the higher pay. But bottom line is an employer has to have that job available for them if at all possible. The employer can't decide to just keep the replacement instead of the person that's taking the leave. That's not legal. They have to bring them back to that job. Now, if they don't, that could be a human rights violation. That could be an Employment Standards Act violation. That could be a wrongful dismissal. You name it, that's wrong. Now, the exception to this would be a situation where the job legitimately does not exist. There's nothing available. Maybe the department shut down and everyone has been let go. Well, there's not much the employer can do about that. But short of those extreme situations, yes, an employer has to take back the father, the mother, when they come back from parental leave.
Let me take a little. I got one more question, but let me take a little bit of a sidestep. That is different than a leave if you're off on a medical leave, right? Coming back to work.
Yes. So you don't have quite the same level of protection if you're off on a disability leave, a medical leave. Now, you still have a right for your to have your employer consider you and for your employer to make all efforts to take you back. But that job is not guaranteed. Your employer could decide to keep the replacement instead of you, as long as they still try to find you another job. In the disability leave situation, if your employer doesn't even try to bring you back, doesn't deal with you, well, that's a problem. That's illegal. You don't have quite the same level of protection with disability leave, but still pretty good protection anyway.
You know, 18 months, if you think about it, 18 months is a good stretch for a new parent off on a leave. Does that time off, does that count for severance if it came down the pike like that? Is it continuous, that time that they're not even in the office or doing their job?
So even though you're not working for 18 months, that time counts towards your seniority, towards accumulating severance, towards accumulating your vacation time. For example, after 5 years, you may get more vacation. So that counts. So let's say you've worked for a company for a year, and then you took a 1.5-year maternity leave. The day you come back, you're now a 2.5-year employee. So that counts, and that's especially important when it comes to severance. If at some point you are let go, the more seniority you have, the more severance you get. So yes, that time does count towards your seniority.
I mean, the moral of the story after all these parts and these points we've made after 10 years is the same. Don't mess with mama. That's just, you know, if you're an employer, just watch your step, right? Because they have a lot of good rights, robust rights.
It is that simple. You don't punish someone, you treat them well, you bring them back, you just don't mess with them. You don't do it. If you don't mess with them, you will never break the law.
EmploymentLawyer.ca, again, the firm website where you want to go to find a radio station near you across this country that carries our radio show. We'll get to phone call number 2, Lior, from that show right now.
Told my employer that I was sick and needed a few days off to recover. We got tested. I had to wait a few days for the results, and I had COVID. When I was free and clear and ready to come back to work, got a negative COVID test, all that said and done, I informed my employer that I was ready to come back. The employer thought that I was not clear to come back, that I needed to stay away from work longer. And after showing proof that everything was in my favor of having the isolation period over with, they then said, well, there's actually no work for you right now. Gave me a layoff.
A very common scenario, I would imagine, at this point.
Yes, a very common scenario with the past couple of years. So let's let's take for a second the employer at his or her word that there's no work available for this person. If that is legitimate, then that employer can terminate with severance. They can't just put them off work. You can't be temporarily laid off if you don't want to be. You don't have to accept that. They can't just keep them on ice until there's more work. It's either they bring them back to work or they pay them severance. So if you're not being brought back to work, even if it's for a legitimate reason, there's no work, the company is slow, that triggers your severance entitlements. And that severance can be as much as 24 months pay. Now, in this situation, if his employer doesn't want to bring him back because of COVID, that could potentially also be a human rights violation. If your employer thinks you're still sick, or because you had COVID, you can be sick and infect others, that may be a human rights violation. At least, though, that triggers severance. And I want everyone to remember, if you're trying to come back to work, whether it's after having COVID or for any other reason, if you're not being brought back to work, that triggers your severance rights.
We are going to grab another phone call, our third phone call from the radio show, but we'll do it after a short break, so stick around for that. In the meantime, reaching out anytime, 1-855-821-5900 and help@employmentlawyer.ca. It's the Employment Law Show. More coming up. People think contractors aren't owed severance. EmploymentLawyer.ca says that is a myth. Many contractors are actually employees and are entitled to full severance pay. Always check with the employment lawyer first at EmploymentLawyer.ca. How do you force insurance companies to pay long-term disability claims?
Insurance companies deny legitimate claims all the time. They're playing the odds. They know that most people are just going to walk away.
Your insurer may ignore you, they may even ignore your doctors, but they can't ignore us.
We know how insurance companies work. We know their weaknesses. We know how to use the legal process to force them to pay you what you're owed.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think you are only owed 2 weeks' pay when you lose your job. EmploymentLawyer.ca says that is a myth. You may be owed much more than 2 weeks per year. Don't settle for less. Always check with the employment lawyer first at employmentlawyer.ca. Okay, welcome back. I got a few minutes left to go, Lior, in this half hour, so we'll grab phone call number 3 from our radio show right now.
Calling on behalf of my mom, actually. She's been a retail employee for about 20 years, full-time. The company recently changed ownership. Without any knowledge, any new kind of employment contract or terms have ceased benefits, taken away vacation time and such. It has changed substantial terms of the agreement. Does that not constitute constructive dismissal?
Great question. Excellent question. So let's start with the fact that if in a sale of a business, if you continue working with the buyer, your seniority carries through. Unless you sign something that gives up that seniority, it carries through. That's a good thing. Now, in this situation, yeah, that's a constructive dismissal. An employer can't just decide to get rid of benefits, to change terms of employment significantly. If they, reduce your vacation from 5 weeks to 2 weeks, or they take your benefits, that's a big deal, right? Especially benefits. That's an important term of employment. So in this situation, yeah, that employee can choose to continue working and accept these changes, or she can say that's a constructive dismissal. By changing my terms of employment, you've terminated me. Now I have to get my severance. Of course, the question then becomes, how much severance is owed in that situation? Well, let me show you once again. We did that at the beginning of the show, but I'll show you again. Let's go to pocketemploymentlawyer.ca, and let's use our severance calculator tool, and let's see how much severance this person is actually owed. So this person is a bit older, in their 60s, been there for 20 years. It's a constructive dismissal, so they haven't been offered any severance, except you see in the bottom there that she's owed as much as 22 months' pay. 22 months' pay. So that works well in a constructive dismissal or a regular dismissal. Keeping in mind, of course, your employer cannot just change significant terms in your employment.
TerminationQuestions.com. I'm going to slide this one in quickly, or I know you can pull it off. This one's from Violet. She writes in, she says, my employer recently put me on a performance improvement plan. After listening to your show, I realized that this likely means that my boss is planning on firing me in the future. What can I do to stop that from happening?
So the bad news is that there's probably not much that can be done to prevent your employer from firing you. If they're going to do that, they're going to do it. And there's not much you can do to restrain them or to physically stop them from doing that. What you can do is to create a situation where you can't legally be fired for cause. So if she's been put on a performance improvement plan, it's possible that what the employer is doing is building a case to try to fire her for cause so they won't have to pay her any severance. Yeah. So if she disagrees with it, she has to say so in writing. Send an email, a note to her employer outlining the reasons why she doesn't believe that the performance improvement plan is legitimate, what the concern that she has is, and what the truth is. By doing that, even if the employer doesn't respond, just by sending that email, it's going to be that much more difficult for her employer to terminate her employment for cause. They can still let her go. Okay, your employer can let you go, but they're going to have to pay severance. So whenever we're talking about how do I avoid being let go, what we're really saying is, how do I avoid being let go for cause so that I get my severance? Remember, severance, John, is as much as 24 months' pay, so it's worthwhile to do it properly.
That's fair. That's fair game to say about anything you disagree that may come down the pike with your employer. If you disagree with it, don't sit back in silence. It's like it never existed. You've got to put everything in writing, right?
If you send an email to your employer and they don't respond, you can take that as acceptance. By the way, same applies to you. If your employer sends you something and you don't respond, that's an acceptance. So never accept something unless it's correct. If you don't agree with something, say so in writing.
Keep that knowledge in your head at all times. And by the way, you can reach out now that we are done for this half hour. That is really simple. The phone number, 1-855-821-5900. Again, 1-855-821-5900. Email that we use every show is help@employmentlawyer.ca. And where do we find that severance pay calculator? That's also free, pocketemploymentlawyer.ca. Thanks for joining us, and we'll catch you next time, The Employment Law Show.
Closed captioning of this program is brought to you in part by SeverancePayCalculator.com. Find out how much you are owed right now. SeverancePayCalculator.com.